prosecutor. The prosecutor, he just said the burden of proof was on the prosecutor. So if you ask a question about evidence, why would the judge be answering?
So you just kind of keep going until you wear them down, and the state of Arizona is not there because the state really doesn't exist, is what you're saying?
Well, empirically it does not exist. It's just a fiction. It only exists on paper. They don't want to get into that, though. And so, in my experience, I'm speculating on that. I believe that the reason why they refuse to answer yes or no is because they don't want to discuss evidence, especially when you're dealing with a traffic situation or taxes. The last thing that they want to discuss are the facts. They do not want to discuss that. And so especially in tax cases, or proceedings, I should say. There's never a case. So they always want to steer away from that. So in my experience in over 10 years, if the judge does not immediately bail out the prosecutor.
In other words, answer for the prosecutor.
Right. If he doesn't, or make it so, or get upset and say that the prosecutor does not have to answer that. So in most of the time, when the judge does not help him, the prosecutor will either withdraw the charges so that he can avoid it, or the judge will dismiss on the spot for a failure to prosecute. I mean, if you can't even get to whether there's evidence of a complaining party, there's no point in going any further.
Well, is there ever evidence of a complaining party? Say, for example, an attorney files a suit to foreclose on somebody.
Okay.
And it's just an attorney, right? And they're representing Wells Fargo Bank N.A. or somebody else. I've actually heard of people that have had the thing dismissed because Wells Fargo Bank wasn't there.
Well, it depends on the circumstances. I'd have to know a little bit more as to what was going on.
But is that the same idea? Or not?
It may, not really, because ultimately yes, because corporations are fictions also. They only exist in the mind. So, but I don't think that's why the judges may have been throwing it out. It may have been on other grounds that we're not aware of.
So legally, can an attorney then represent a fiction like Chase Bank or something and pull it off?
Well, they do it every day.
They do it every day. Yeah.
They do it every day. Going after,
whether or not it's right or legal or whatever the word is, or lawful is.
It's probably legal or lawful, but it's not something that if you really got down to it, they could not actually produce. And if they had to produce evidence of a complaining party there, they would have to show the actual people that they're claiming own the property, like the stockholders and things like that.
Mm-hmm. Here's an email from Leroy. He is in Southern California. Wants to know what is a common law court, and can we ask for those?
Common law court I don't think exists anyway. I think it's just another label. I think it's but I think I understand what he's getting at as far as that there has to be an injured party, which is something I'm very big into, that there has to actually be a case of controversy. But that requirement is there, whether it's a common law court or an admiralty court or whatever court that they happen to be operating under, because under their own rules, courts can only hear cases or controversies, and that's what is important, not the label that's on the actual court. That's just my experience from, my practical experience of being with them. I mean, I had someone raise this issue as far as the fringe on the flag, and I had someone storm out of a workshop that I was doing in Seattle, and I just explained, look, let's look at it empirically. When you're going to court, you're forced to be there. You either show up or they send men with guns. They're using deadly force if necessary to get you into that building. So the whole thing has nothing to do with your consent. But they're pretending to be administering justice. Now, does the fringe on the flag, whether it's there or not, does it change those empirical facts? No, so it's not relevant. So I really don't focus on what they're calling the jurisdiction.
What do you focus on?
I focus on what's really happening. I don't accept them as anything other than violent individuals who are more than happy to kill me. to get what they want. I don't accept that they are judges. I don't accept that it's a court. It's just I just look at them as people, and I don't make assumptions. I go in and I want to disarm them psychologically so that they don't see me as a combatant. So when I go in, I always go in with an unsigned plea of no contest or guilty. I just don't understand. I have a few questions. So without making really any assumptions, I just go in and start asking questions. But based on experience, I know when I get to a certain point, they're going to contradict themselves. And it's more effective to get them to contradict themselves, meaning the judge, than to try to get him to contradict the law. Most of us listening to this show, I'm sure, have experience with someone who's gone to court, and they'll say, "That's not my, that's your interpretation," or that, they just don't buy it. They view the law different. Or, if you try to tell a judge that he's violating the Fifth Amendment or something like this,
yeah, man, they get feisty.
Well, they don't care. Ultimately, they just don't care. But if you get them to contradict themselves, now they're going to be, because look, they've got to make it look good, whether it's a common law court, an equity court, or a statutory jurisdiction, whatever they're calling it. They have a show to put on. They have to make it look good. And even when they do the most ridiculous things, what I always suggest doing, look, it's very easy to get them to tell you what the law is after they've even violated it. And all you have to do is, if they do something that is totally against the law, instead of telling them, "Hey, you're violating, the rule," if you just demonstrate it by actually doing it, they will tell you what the law is, and that is incredibly embarrassing because now everyone in the room knows what the law is because the judge said so. So you can see, and everyone knows in the courtroom what he just did was wrong. And a really good example of that is when you challenge the attorney on whether he's got there's evidence of a complaining party. Because you're challenging the attorney's right, if you will, to appear in a representative capacity. He's not there for himself. He's there for someone else. So if they turn around and refuse to allow me or you or anyone, if they refuse to allow you to challenge the appearance of the attorney, well then, if you want to show how crazy that is and how against the law that is, don't tell the judge that's against the law. You pull somebody out of the audience and you tell them, he's going to assist me today, because I guarantee you the judge and the prosecutor are going to jump all over it. Well, wait a minute. It's no different than when I've been able to impeach every police officer they've ever brought against me. Well, I can get the judge to impeach the police. I can get the judge to do that for me. So if the judge says the witness is incompetent to testify, and they take the testimony anyway, if they keep taking his testimony and refuse to strike it, well then it's very easy for me to demonstrate how illegal that is just by pulling anybody randomly out of the audience and doing the same thing.
Oh, and which they don't allow you to do.
Well, yes. If you want the judge to actually tell you point blank that he's making a mistake because he's going to tell you what the law is in his court,
right?
If you want him to convince everyone in that room that taking the testimony of a witness who is incompetent is illegal, then you pull someone randomly out of the audience, out of the peanut gallery, and watch the judge and prosecutor attack that witness on competency and credibility. But wait, so you now know what the law is. He's just told you because you are demonstrating this. And so now you can revisit, well, wait a minute, sir. You declared the cop incompetent, and you took his testimony. So obviously that doesn't apply. So anyway, this is all getting to where you're not necessarily being combative, but it's like, I call it Zen in the art of litigation. Mm-hmm. You're using their energy against them. Oh, okay. And so through experience, that is much more effective. And
you continually do that by asking questions rather than taking a position.
Right. Your position is really taken up in the form of a question.
Right. Very powerful, isn't it?
It really is, because when we go in here, we know that they're just trying to take money. And if you come off as combative or argumentative or contradictory, they're going to disagree with you and that's it.
Yeah, do the old gavel, and there you go. That'll be $100 or whatever.
Right, and you have not established a record that is helpful for you. But if you go in and you ask a police officer 2 questions, and the judge only allows an answer to the first one, you got a really, really strong appeal for denial of cross-examination. So, and at that point, though, if you can appeal on the denial of cross, which you can clearly show with only 1 question, you are diverting attention away from what the actual charge is, so that you don't have to try to prevail on an issue that you're not required to have a driver's license or you're not required to pay income taxes. The only issue before the Court of Appeals is, did the court err by denying cross? And that's an absolute 100% of the time. If it's the only witness against you, it's automatically reversible. You don't have to show prejudice. You don't have to show that the outcome would have been different. You just have to show what happened. And so that's why it's so much more effective to just ask the questions and not be argumentative.
Okay, we're going to go through and have a traffic court right after the break, okay?
Sure.
Okay, I'll be the guy who has a ticket, and you can be the judge. And you tell me what to do on the sly. Your book is Adventures in Legal Land, right? And it's on your website, MarcStevens.net, correct?
Right.
And before the break, what's your radio show? LRN.FM. Tell folks how to listen.
It's on LRN.FM, and you can also hear it on my website, MarcStevens.net.
And when is it on?
Every Saturday from 3 to 5 Central.
3 to 5 Central on Saturday, and you can listen right on this website.
Right.
Huh. And you guys take calls and stuff like that?
Yeah, I should be able to take calls again live this Saturday.
Well, it should be fun. Okay, stay right there, MarcStevens.net. We're having fun this morning talking with Marc Stevens, MarcStevens.net. There's a book out that friends of mine have recommended. I do not have it as yet. I'm going to get it. Adventures in Legal Land, and he does a radio show on MarcStevens.net, 3 to 5 Central on Saturdays. Just before our show that we do, Mark, on 6 p.m. Central, we do a 2-hour show with Andrew Goss on how money works and what money is and what money isn't, and the Fed and all that with the currency historian. If you ever get a chance to hear that, it's really... He's taught us a lot about the whole money thing, boy. It's a trip, isn't it? Marc Stevens?
Yes, yeah.
The whole money thing, I guess, it's probably going to be one of the big ones that we're going to be looking at in 2011, isn't it? It's
well, and yes, and the money issue is just one problem of many that stems from the fact that government support for what we call government is compulsory. Because that's the only reason why people use Federal Reserve notes is because they're forced to.
They're forced is compulsory. Well, let's talk about that before we do the traffic court thing, because you've used that term, Marc Stevens, a lot this morning. So when something is a compulsory action, does that invalidate it, or it's not a contract, or what? Talk about that a bit.
Well, right. And, all human interaction should be voluntary, and that is really the basis of why everything I do in court or when I am interacting and trying to resolve problems people have with bureaucrats, that is the basis. It all comes from that.
All human action should be voluntary, which is really a very deep spiritual rule, isn't it? That everybody is free and has the right to make their own decisions, and we shouldn't force anybody to do anything.
Right, exactly.
Yeah.
That's the core, and it all comes from that, and that's why every problem associated with what we call government, all of them go away when that compulsory part is taken out. That's what causes it, and something I go into in a lot more depth in my new book, which I will have out this year, that there is a just devastating economic and psychological damage that we can prove empirically